Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, several weeks ago, we did a video about a lawsuit currently filed in the Northern District of Florida by Agricultural Commissioner Nikki Fried against the Department of Justice as it relates to their denial of 4473s for those who happen to be medicinal marijuana patients. Now, the government filed a summary judgment motion, a motion to basically dismiss the lawsuit, and chose some amazingly choice language as examples as to why they believed they were in a lawful position. That drew the attention of many of us in the 2A community, which led to us doing this video, which was not so much about the lawsuit, but about all the outrageous claims and language that the Department of Justice chose to use in defending their motion to dismiss this lawsuit. Well, today, we have a real treat. We are going to be joined by Dan Russell. He's a Florida attorney out of Tallahassee, Florida. He's with the law firm of Dean Mead, and he represents Nikki Fried, who is the plaintiff suing Merrick Garland in the Northern District of Florida. So, happy that he could join us today so that we can have a conversation about a response on DOJ's reaction to medical marijuana patients. Okay, so like I said, the issue we're talking about today is this ongoing lawsuit in the Northern District of Florida. The case is called Fried v. Garland, and this deals with a lawsuit to stop Department of Justice and ATF from denying firearms applications 4473 to those who happen to be medicinal cannabis patients. Now, as I mentioned earlier, the plaintiffs filed suit, and the government, Department of Justice, immediately turned around and filed a motion to dismiss under summary judgment, which we'll talk about with Mr. Russell here in a minute. The language they chose was crazy in their justification for why the plaintiffs had no claim here. And so with that, we're going to bring Mr. Russell in, and we're going to talk about the lawsuit and get you up to speed on what's going on in the matter of Fried v. Garland. Well, hey, everyone. Hey, it's a real pleasure to be joined by attorney Dan Russell out of Tallahassee, Florida. He is with the law firm of Dean Mead. Now, Dan, you represent Miss Fried, who is, I believe, the Commissioner of Agriculture for the state of Florida and has brought suit against the Department of Justice in relation to them denying firearms applications, 4473s, for people who answer honestly about their use of medicinal marijuana. Why don't you fill us a little bit in on how you got involved in the suit and where that suit sits today?
Sure. Thank you, William, for having me on. I really appreciate the opportunity. The genesis of this lawsuit for us goes back time long ago before COVID. We were having this conversation about, and it came up in the context of one sentence in the DOJ form where you are purchasing a firearm, where historically the sentence and you would know it better than I would with your specialty, but it effectively says, are you in the possession or currently using illegal drugs?
Right.
We completely get it. Dangerous individuals who are addicted to drugs buying off the street and cocaine and all that sort of thing. We don't want those folks buying a gun. That's not the issue. What caught our attention was when they added a subsection there that said, to be clear, effectively, buying medical marijuana in a state that has deemed it legal does not make it legal in the federal context. It's still illegal under the Controlled Substances Act. It's effectively saying that. When that language was added, it got the attention of Commissioner Fried and myself and my law partners, and we met with the commissioner and said, Are you interested here? Does it pique your interest the way it does ours? And immediately it did. And I knew we would get to the point where we would be participating in this litigation. But then it got even better for us. We file our initial lawsuit. And then as you know, and as I'm sure all of your followers know, the law around gun ownership was modified by the Supreme Court right after we filed suit. It doesn't have anything to do with medical marijuana or the patients or medical marijuana patients being able to buy a gun, but it has everything to do with the government's ability or inability to tell folks who does and does not have a Second Amendment right in this country.
Right. Now, for our viewers, just to get you up to speed, the question that Dan's referring to on 4473 is question 21E. And that question says, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? And then in big, fat, bold print, warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside. And Dan, I live in a state, which was actually us and Colorado were the first two states to go full legalization for recreational purposes. So there are a lot of folks here in Washington state who are lawfully using marijuana recreationally who would also fall into this category because they, according to the federal government, are an illegal user. Now, you mentioned you filed suit and then the government filed a response brief. Okay. And
did it ever?
Right. And one of the things that you pointed out is under the New York Pistol and Rifle Association v. Bruen, that our constitutional analysis that we're going to look at firearms restrictions has greatly been narrowed, and that absent something in the text of the Constitution itself or something in history, really gun regulations that aren't supported by a historical perspective are unconstitutional. So that was an argument that your side very wisely offered, and then the government had a really bizarre response. Why don't you talk about that for a minute?
So as we were going through the process, we saw the Bruen ruling and thought to ourselves, this is significant for our case. We need to amend our complaint so that we can argue it now in the context of what the Supreme Court has just given us. We were so surprised at the government's response, and they've said, yes, the law on gun ownership and gun regulation in this country has changed. It now requires a historical context that could point to it and say, at the time of the framing of the Constitution or the passage of the statute, there was a historical analog for what we're doing now. So effectively, in the late early 1800s, was there something analogous to keeping medical marijuana patients from having a gun? And the government said, yes, let us provide some examples.
Right. And the problem is that, so what we're doing is we're trying to come up with historical examples of where a government believed that a class of individuals was just too dangerous or too untrustworthy to allow them to possess firearms. And the examples they came up with were what again?
Two personal faves. There was a long list. Two personal favorites: Catholics, Indians. Not my word, the federal government's word.
Right.
Native Americans is what I'll say from here on out. But the verbiage used by the federal government was, we historically have taken guns away from dangerous people like Catholics and Indians.
And again, just to highlight, that was the term they used, was Indian. They did not use the more modern, correct nomenclature, Native American. They used the term Indian, correct? That is correct.
And it was in a long list of things, none of which have anything to do with the plaintiffs in this case, who are the Commissioner of Agriculture in her official capacity, and individual plaintiffs who simply want to treat their medical conditions that they have a state constitutional right to do in the state of Florida. Be able to simultaneously have a right under the Second Amendment of the United States Constitution and the Florida Constitution, which grants them access to medical marijuana.
And in these individuals in Florida, and it was this way when Washington only had a medicinal industry, but you have to have an actual medical authorization from a real MD. So therefore, this is a doctor who, in his or her professional opinion, believes that this is an appropriate treatment for whatever ailment the person is suffering from. Agreed?
That is correct. There are approximately 800,000 Floridians with a medical marijuana card. Those people have done all of the following things: been determined by a licensed medical doctor that they have a qualifying condition that our state constitution and our legislature have enacted. They have gone through, met with the physician, gotten their card issued by the state's Department of Health, and in order to purchase the product, it obviously comes from the state of the doctor, gone to a licensed medical marijuana treatment center, a dispensary, to make that purchase. All of which is protected in our state constitution, also in our legislation. It's in a statute for 6 years now. It's been in our state constitution for about 4. Be that as it may, these are not criminals. These are people who are following the letter of the law. They are not dangerous in any capacity, but the federal government thinks they are way too dangerous, for their briefing, to own or possess or purchase a firearm.
And let us remember that all of these people have one other thing in common, which is that they had their willingness to be 100% honest in answering their 4473, because in many of these instances, they could have marked the box in the negative, probably wouldn't have been a way of verifying that. It would have been a dishonest answer, subjecting them to criminal liability. So I'm not suggesting people do that. But these are people who are like, hey, listen, yeah, I do have a medical condition. This is the medicine that I'm prescribed. And therefore, the answer to that question is, yes, I am a user of this substance, right?
Absolutely. There is no, and again, we're both lawyers, so we'll just go ahead and put it out there. Don't lie on the form.
Right.
Don't lie on the form. If a hypothetical person wants to risk imprisonment for lying on a federal form, there is no way to cross-reference our Office of Medical Marijuana Uses Registry, who could tell you who all has a medical card and access to medical marijuana in Florida, with who's buying a gun at your local gun store. That doesn't exist, at least.
And even if they could, just because a person has a medical authorization to use cannabis does not mean that they have chosen to actually use cannabis. Just like my doctor prescribes, hey, take 1 aspirin every day or something like that. I may or may not take an aspirin every day.
Very true. That's a very valid point. It's been argued in other cases that weren't successful, so we avoided it in this case, but it's absolutely true.
Now, but one of the other things, and again, I think that it was the government's response that really drew the attention to this lawsuit. This lawsuit, I think, was kind of chugging along, maybe getting some attention down in Florida. And then it was the government's rather outrageous response that kind of drew the national attention of the 2A community. One of the other things that the government claims in there, rather boldly and brashly, is that even referring to it as medicinal marijuana is a misnomer, because marijuana has no medicinal effects or benefits to an individual. What say you about that response?
So while I appreciate the pleadings of the federal government's lawyers and Congress's inability to change the law over the last 50 years as society has evolved and we've learned more about I trust the physicians licensed to practice medicine in the state of Florida more than I do Congress. That's just me.
You mean it's kind of a trust the science type thing?
I mean, I don't know if it's in vogue anymore, but if my physician gives me a line of things that I need to do to get better, I'm probably going to do those things. Right. And if one of those things is unique and a little different than what you would get at the hospital, potentially you've run out of ideas through the traditional medical system, and you're working with a physician who has an alternative treatment to treat whatever it is that it might be. A lot of people experience significant relief from their epilepsy, not because of their epilepsy medicine, because it has really severe side effects. They get the same relief from medical marijuana without the side effects. Now, do the side effects include hungry, happy, and sleepy? Of course they do. But those are much, much reduced to some of these very severe epilepsy folks who are having to treat with very strong medicines. And those prescriptions
let's take a look at another
difficult for the body to deal with.
Yeah, and here's another common one that we see, chronic pain management. Okay, now we know what the opiate-based painkillers can do to an individual. We know what it's done to our society, and everybody has a friend who started taking these pills after a back surgery who ultimately ended up getting hooked on these things, because unfortunately, this is how that medicine works. I have seen a lot of physicians now begin to resort to medicinal cannabis for pain management, and I'm assuming you have found a lot of people in Florida that are using it for the same purpose. And I think we can all agree that the long-term health effects of opiate-based painkillers compared to the long-term effects of exposure to cannabis are significantly different.
There's no question. We've spoken with Florida's medical community. All their leaders are out there saying exactly that. And it gets right back to the case. The decisions that I make in consultation with my doctor are protected. When those decisions then bring me out into the real world, where I came into this doctor's office with a Second Amendment right, I think I should leave it with that also. That's our position, and that's how simple our argument is. I don't think the decision to treat my ailment, and I can't just, in the state of Florida, there's no exception for I kind of just want it. There are very significant medical ailments that are being treated here. Cancer, epilepsy, all those sorts of things that are not, oh, haha, I'm just going to get high.
Yeah, I'm a little stressed out. right?
What are we talking about? The list of things we put in our Constitution, our legislatures added to our statutes are serious medical conditions. And people take this very seriously. And like you mentioned,
they're very legitimate and verifiable medical
question.
conditions.
No question. And the doctors are saying, we think this will help. And if I agree with them and I go to that dispensary and make that purchase, I am doing so, and according to the federal government as the law is now, losing my rights via the Second Amendment the moment I make that purchase at the medical marijuana dispensary. And we don't think that's where society is, and we definitely don't think that's where the law is.
Now, the government frames this whole issue about saving lives because we're going to keep guns out of the hands of dangerous people. But I want to kind of point out one of the fallacies of this whole enforcement effort through 4473, because let's take an individual who is a raging alcoholic, somebody whose blood alcohol level is probably never at a 0.000. They could still answer this question honestly and be in possession of a firearm, could they not?
100%.
Okay, let's take a look at someone, and this is one I see unfortunately with some frequency. The individual who is constantly on a cocktail of both painkillers and mental health medications, who I sometimes call the DUI in perpetuity. Now, these drugs are all being prescribed. They're taking them according to the prescription as provided by their physician. They could answer this question honestly and still be given a firearm as well, could they not?
Absolutely. It's not, because we're dealing with medical marijuana as medicine, as the federal government, and I'm sure would say it, we don't get the same protections in the medical marijuana community as the prescribed medicines community does. And as much as you say, we all know someone who's probably treating an ailment with medical marijuana, we all definitely know somebody who's had to deal with the aftermath of an opiate issue.
Yes, yes.
Mild or severe, we all in this country know somebody over the last 20 years when we've been dealing with this who's had a horrible reaction or dependency on opiates.
Well, and then how many
and they can buy a gun, no problem.
How many deaths do we have in the last 20 years due to opiate overdoses versus how many deaths do we have due to marijuana overdoses?
So I think the next medical marijuana overdose would get us to 1.
That's right. That's exactly right.
So the physicians I've met with, I've asked the question over and over because I find the statistic unbelievable, but it just continues to be true, and I'm not a scientist, I know that it is what it is. On a molecular level, the THC molecules are too big to overtake the human body in the way that prescription pain pills do, where you can overdose. You know, the fentanyl problem that we have in this country.
Yeah.
That doesn't exist in medical marijuana because of how the substance interacts with your body. Can you get sick? Probably vomit, fall asleep, do a whole, are there bad reactions? Sure. Is it anything like prescription medications, in particular opiates? No, it isn't.
Now, it would almost seem, and correct me if I'm wrong, but it almost seems like if you're a Florida medicinal marijuana patient, the federal government is treating you no different than the person who's going to the crack house to buy crack cocaine all the time.
You're absolutely right. There's no medical benefit according to the federal government, and you are too dangerous to own a gun. You are committing a crime according to the federal government every time you walk into that dispensary and treat your body and treat yourself with your medical condition with medical marijuana. It's unbelievable to me that the government, one, took the position at all. Fine. But the way it was articulated, these people are too dangerous to own a gun. These people in our litigation, aside from the commissioner in her official capacity, are individuals, one of whom is a former member of the US military and one of whom is a retired police officer. I don't find them dangerous in any capacity at all. These people were fighting for our freedom and protecting our community. And now, because they've gotten to the point in their life where unfortunately they've gotten sick with something and are treating it with an alternative medicine as it's defined now, have lost their Second Amendment rights for that. They're too dangerous to own a gun. Think about that. It's crazy. It's crazy.
Well, and then we began to worry about what the chilling effect is going to be in the medical community. And for example, in Washington State, we have laws that if you fill out a 4473, they can access your mental health records as well. Now, I am always encouraging people that if you have a physical ailment or you have an emotional issue or mental health issue, you need to seek treatment right away as fast as humanly possible and do, as you suggested, listen to what your doctor says and do what they say. If people have to choose between taking care of themselves or forfeiting their God-given right of defending themselves, that could have a significant impact on the physical health of America. What do you think of that?
It's just such a unique situation where we have the government telling us exactly what you said, but in reverse.
Yeah.
Don't be honest and forthcoming or get mental health treatment, for God's sake. A lot of us were locked in the house for a year, but we can't go seek mental health treatment for fear of losing our Second Amendment rights. I mean, I have a small child. COVID, at the very beginning, nobody knew what they were doing. Schools closed, everything locked down. We were locked in the house for a while. I mean, not literally, but effectively, yeah. I think there's a lot of people who got out of this COVID environment were like, I probably need to talk to somebody about
Absolutely.
I'm losing my mind.
Correct.
And because of that, now they've lost access to firearms to protect themselves and their families in their own home. I don't understand. The same home that was so important, we had to lock ourselves in it. Now I can't protect it if somebody else wants to come in.
Yeah.
Because I wanted to go talk to a doctor and maybe, get a Zoloft or, God forbid, treat myself with medical marijuana. It's crazy.
Yeah. Where do you see, what I believe that the government's response is due tomorrow, right? Which would be September 21. What's the next step for you guys after the government responds? Where's this suit going?
Well, best case scenario, we get a reply tomorrow from the government and the judge allows the case to proceed. We're just procedurally, we're at a spot now where the government has moved to dismiss us.
On summary judgment?
Yes, exactly.
Yeah, and so for my viewers who, we geek out here about lawyer stuff, what a summary judgment, just so everyone understands, is when a plaintiff files a suit, if the defendant says, hey, listen, they don't have any claim here, this is essentially just frivolous, it's a bunch of BS, and the court agrees with it, they can summary judgment a case out and say, no, you haven't even stated a claim here, right?
That's right. It's in one sentence, the judge says, there's no case here, move along, nothing to see.
Okay. And so the government's outrageous response was their motion to basically throw this lawsuit out.
That's right. And there's one part of the lawsuit that we haven't mentioned. It's a little nerdy, so I'll go quick.
Okay.
The portion of the federal budget that prohibits the Department of Justice, which the ATF is part of, from spending a single penny on interfering with a state medical marijuana program. So going back to my individual patients, not the commissioner. My individual patients have a state constitutional right, following their state legislative law, are following the federal government's guidance, which says we cannot spend money to prosecute you, but we can keep you from owning a gun. There's the Rohrabacher-Farr Amendment, which has been in every piece of funding legislation at the federal level for years now, prevents the DOJ from going in and interfering in any capacity with a medical marijuana program. We believe the simplest way for the government to just get past this and that we could win is take the sentence off the form. If it just says what it used to say, that's a really great step for the federal government to go in the right direction and say, you know what, this is a Rohrabacher-Farr violation. We shouldn't have that language in there. We don't want people who are, using illegal drugs to own a firearm, but at the same time, we acknowledge that 37 states, including all the major states, have passed marijuana legalization in some capacity, all of which include a medical program.
Right.
That's what we think the next best step would be.
So is it your opinion
knows.
that if question 21E was amended to, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or other controlled substances, and that was the question, a medicinal marijuana patient could answer that in the negative? Because they're a lawful user of it at that point, right?
I think it then becomes sort of like where we are with all of it. We understand that the Controlled Substances Act prohibits the possession of marijuana in the United States. But we also know that Rohrabacher-Farr prevents the federal government from enforcing it. So we're right back to where we started.
Well, here's a more simple solution. How about, shockingly, we just reclassify cannabis down to where we got alcohol and tobacco? And then each
Well,
now each state can decide what they want to do with it.
You're just being entirely too reasonable.
Yeah.
You want Congress to act in a way that helps regular Americans?
Right. Well, and for those of you who are not in recreational states, let me tell you what happens when you do it is because the federal government still has all of its constraints on it, you can't use traditional banking. Since you can't use traditional banking, nobody gets to go in and swipe a debit card or a credit card, and it becomes a cash-only business. Cannabis stores in Washington state are like casinos. They got cash all over the place, and guess who knows it? The armed robbers. Okay, and so that's the problem that we end up with in our cannabis industry. It's a very dangerous industry to work with. If this suit continues, if the government fails in their summary judgment motion, what's the next step for the plaintiffs then?
We can't wait to start discovery, take a few depositions. I can't wait for people to have to answer these questions and have that transcript forever. I want to ask, why is a plaintiff like ours in their individual capacities too dangerous to own a gun? Why is that? Is it simply because of their decision to treat an underlying medical condition with medical marijuana? If that's the answer, that's fine. But I just don't know a judge sitting on a bench in 2022 can look at the facts as presented in this case, particularly in light of Bruen. And right. A case from yesterday, which I'm sure your readership and your viewership is following, where gun ownership in America is evolving as we speak. In the last 2 months, we've had major case rulings on gun access in this country.
Yes.
But we've had marijuana in some capacity in this country for 40 years and can't get anything. It's at the federal level. It's so odd. But short answer to the question, we can't wait to get to the discovery phase. We really hope we're able to try this case and get a victory for regular Americans who just happen to be in a position where they think, along in consultation with their doctor, that they can be healthier utilizing medical marijuana.
Well, and that's the thing. They don't think that. It's their physician who thinks that, which is there's a reason they have the letters MD behind their name. That's their field of expertise.
We have thousands of treating physicians in Florida who have gone and taken the course. And after taking the Florida Medical Association's course on this, have decided, I believe in that, and I think I'm going to start recommending medical marijuana for patients. These people went to medical school and we trust them with our lives, but not on are people too dangerous to own a gun or not. I don't understand that. I just fundamentally don't understand.
Dan, just real quick as we wrap this up for our viewers, the name of the case is what?
So it's a long list of names, but it's effectively Fried v. Garland.
Fried v. Garland. Okay. Yeah. All right. Fried v. Garland. And it's filed is it in the Northern District of Florida?
It's in the Northern District of Florida. Which is located in Tallahassee. That's correct.
And just because only you will have the expertise in this, how is that venue? Do you feel good about that venue and having this action filed in the Northern District of Florida?
Yeah, no, I mean, we have, because the seat of state government is here, I think the judges both at the state and federal level are used to sort of odd cases. Mm-hmm. It's not just a traditional civil or criminal bench here because of what's constantly happening at the
legislative level.
That's exactly right. A new law, the constitutionality have changed it. The judges here in Tallahassee are used to dealing with that, and I have immense respect for the judge in this case, and I think whatever the decision is, it'll be the right decision.
All right. Dan, I can't thank you enough. We promise you'll come back and do this again after we have some more developments on this.
100%. I'm looking forward to being a recurring guest. Can't wait.
All right. Excellent. Thank you so much for your time today.
Thank you.
Okay. Once again, I want to thank Mr. Russell for taking time out of his busy schedule to join us today and get us all educated. Now, the lawsuit, again, for those of you who want to file it, is Fried v. Garland. We'll put the links for it down below. If you have any other questions about this lawsuit or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.